start introductions.
Hey, Scott.
Hi, Scott. Thanks for
Hey,
joining.
Tim. Hey, Lori, how you doing? Hey, Tim, how you doing?
Great. Great to see you.
I love Jackie Gorton's image there of an empty chair. I think I'm going to make that my image. All right, we are at 12 o'clock. And Maria, who is our great new staff person at Legal Aid of Marin, Maria Chumbes, do you want to let me know if I should wait for you to finish admitting everybody, or does it look like
I'm still getting people trying to join, and we only have 16 people on, counting us, legal aid staff, and we have about 40 people that are supposed to be on, so it's up to you, really.
Well, I'm going to start pretty promptly. I just wanted to know if you need a minute or so to let more people in.
Nope, we're all good.
Okay, well, I am at least going to begin with just introductions. So my name is Laurie Joyce. I'm the Pro Bono Director at Legal Aid of Marin. And if all of you could put yourself on mute while somebody else is talking, that would be great. And so I am the Pro Bono Director, which will give you an immediate clue as to why we are holding this webinar, and that is we're hoping to inspire all of the lawyers who are attending to take on some pro bono work with Legal Aid of Marin in the area of eviction proceedings, because we're expecting quite a wave of evictions to start coming into Marin Superior Court. And there are really two specific ways we're hoping, and limited scope, hoping to get pro bono assistance. One is to help most tenant defendants to complete their answer after they're served with an eviction complaint. To complete the answer, it's a judicial counsel form. We can walk you through it to understand how to serve it by mail on the adverse party and do a proof of service, and to get it filed with the court. So that's one area. And or the other pro bono project we're hoping to get assistance with is mandatory settlement conferences. And by the way, these are all this pro bono assistance will be done remotely by phone. None of it's in person. But the second pro bono assist we're hoping to get is with Marin Superior Court, which will be starting mandatory settlement conferences and unlawful detainer proceedings beginning Thursday, December 3rd, right after Thanksgiving holiday. And we think they will be going every Thursday afternoon at 1:30. It's about a 2-hour limited scope assistance to help unrepresented parties in their settlement proceedings, to see if we can assist assist the side you're helping to reach settlement in lieu of the risks of going to trial. I want to thank Ben Berkowitz. Are you here? Yes. Ben Berkowitz is the attorney at Kecker, Van Nest, and Peters, LLP in San Francisco. He's also on the board of Legal Aid of Marin, and he has generously offered his firm to sponsor this webinar and to assist with the CLE compliance, which we will make sure that everybody gets their certificates. And I also want to thank Harvard Law School Association of Northern California, who is also sponsoring this webinar. Just a couple of housekeeping items. This CLE will be recorded. Our wonderful staff person, Maria Chumbes, hopefully has already hit the record button. So it will be recorded and posted on our website, which is marinprobononetwork.org. I will email that to all the attendees as well. The PowerPoint that we're going to go through when we share the screen is also going to be posted on the marinprobononetwork.org website, so you can access it there. And Zoom magically will record all of you and your attendance for the full hour in order that Kecker can pull together the CLE certificates for compliance for being here for the 1 hour. And we will also be sending you a survey to complete along with the CLE certificate. Last, if you have questions, if you could please put them in the chat room. We will try our best to answer questions, and those that, if we can't answer all of them, I will put them in writing and send out an FAQ to all the attendees, and we will attempt to answer every question to the best that we can. Our speakers today are Lucy Hollingsworth, who is a senior attorney at Legal Aid of Marin, and supervising attorney Josh Sullivan. Lucy will start off giving a bird's eye view of the quickly changing laws that have come into effect in the last 12 to 14 months that affect unlawful detainer eviction proceedings, both on the federal level and on the state level and on the Marin County level. And then Josh will follow Lucy by talking about the procedure of unlawful detainers. And then Maria Chumbes, I wanted to acknowledge, who is our technician. Thank you. Maria is from the never to be forgotten class of 2020, class of UC Santa Cruz, and she will be off to law school soon, so we're very happy to have Maria helping us. So sorry, I forgot to tell Maria to share screen, and we will be on slide number 2, thanking our sponsors, and then Lucy will begin with slide number 3 in the agenda. And if everyone could mute, I feel like we're hearing an airplane take off or something in the background. Thank you. Again, if everyone can mute except for Lucy Hollingsworth, who will begin.
Thank you, Lori. And it's great to see so many people on this call. So one more bit of housekeeping. In order to get the MCLE credit, we have to have your last name also. So if you could use the rename function on Zoom, and if you just go to the 3 dots in your profile picture, and you'll see rename, add your last name, because we want to make sure that you get your credits. And so this is our agenda today. Again, as Lori said, we're going to go through the current protections, both at local, state, and federal level, and also the notice requirements, which become really one of the most important parts of an unlawful detainer. Quickly on rent increases, and then Josh Sullivan is going to go through the unlawful detainer process for us, as well as the settlement.
So you want the next slide? Right?
Oh. And so we did, once you get a copy, if you don't already have a copy of this presentation, all of these, we tried to give you as much easy access to the resources as possible. So you can click on all of these and go directly to the, whether it's a statute or we have forms later on as well. So the first thing we're going to talk about is the state protections, which is our newest and most protective, and really the one that has the most meaning right now. But there's still parts of the CARES Act as well as the Marin resolution that still apply. So we will quickly go over those as well. And so the COVID-19 Tenant Relief Act of 2020, Governor Newsom signed this into law on September 1st. You are going to hear this a lot from me, this term, poorly drafted. and while we had 2 competing bill proposals that related to evictions that were COVID related, 3088 came about only probably about a week before the end of the legislative cycle. and was really rushed to the floor. So we will see some drafting errors, whether intentional or unintentional, and whether an advantage or not an advantage. A lot of it is yet to be seen. We also certainly hope this will get cleaned up when the legislature returns in January. But for now, this is what we have. And so it protects tenants from becoming homeless from eviction if there's COVID-related rent debt that's accrued between March 1st, 2020 and January 31st, 2021. It also expands our just cause protections. Those were from 2019, and we'll get into that more later. So part of the COVID-19 Tenant Relief Act, I'll also be referring to it as AB 3088, which is a lot easier, is first we have what's called the protected period. And that period is between March and August 31st of 2020, where 100% of rent debt is covered, is protected, and can be converted to consumer debt. Part of that, in order to get these protections, though, both landlords and tenants have certain requirements to meet. And on the landlord side, they were supposed to have provided a 15-day notice to pay or quit. That's as opposed to the normal 3-day notice, along with a notice of tenants' rights that have to do with AB 3088 and a blank declaration that basically just states that, it's something that the tenant signs saying that they were unable to pay rent due to a COVID-related hardship. The landlord was supposed to provide that by September 30th. This was a really complicated bill, and many landlords didn't know to do that. One question we've had in the tenant advocate community is, if a landlord didn't provide that by September 30th, can they even go after that debt from during the protected period? However, I think ultimately we landed on the fact that just like tenants, and we'll get to that, but tenants can avail themselves of 473B excuses, such as not being able to, not understanding their rights, not being able to submit declarations. Landlords will be able to avail themselves of that as well. And so within that 15 days after receiving the notice, the tenant should have signed and dated that declaration that's supposed to be attached to the 15-day notice. And again, if a tenant missed that 15-day period, they can submit to the court an ex parte request saying, excusable neglect, or for whatever reason, they were not able to complete that within 15 days. And then landlords, for the rent from the covered period, they can go to small claims court. The limits are waived, and they can do that after March 1st, 2021, and that debt can be converted to consumer debt.
Sorry to interrupt, but by limits, can you explain what you mean by limits in small claims court?
So normally the limit in small claims court, and certainly correct me if I'm wrong, but I believe it's at $10,000 now. Rents are high in Marin, and many of our tenants owe much more than $10,000. And so even if the rent owed is over $10,000, the landlord still must avail themselves of small claims court. It does not become a limited jurisdiction case. And so then the next period we're going to talk about the transition period, that's September 1st through January 31st. And in that period, only 75% of the debt can be converted to consumer debt, again, as long as the tenant and the landlord do what's required of them. On the tenant side, the tenant must pay 25% of the aggregate of their rent debt during the transition period by January 31st. So they do not have to pay each month 25%, although it depends on what's easier on their finances. But that's one thing that we're hearing is a confusion, is that landlords are requesting 25% each month, and that's not necessary. And again,
of clarification is when you say aggregate, you mean aggregate from September 1 to January 31st.
Yes, the aggregate during the transition period. And so I can't do math, but just as an example, let's say in Dreamland, rent was $1,000 a month. That would be a total of $5,000 between the transition period that would accrue, and the tenant must then pay $1,250 by January 31st in order to be protected from eviction. They still owe the rent, but they're protected at least from becoming homeless. And then the landlord, just like with the protected period, the landlord is also required to serve a 15-day notice as opposed to a 3-day notice. One thing we didn't have this on this presentation, but the state of California recently came out with excellent resources for landlords, including a sample 15-day notice to pay or quit that's in compliance with 3088. And again, that has to be served with the notice of tenant's rights and the blank declaration for the tenant to sign within that 15 days. But unlike the protected period, during the transition period, this needs to be done every single month that the tenant is unable to pay. And again, landlords can go to small claims for back rent starting March 1st of 2021. And then, so what AB 3088 also did, though, was expand protections for what's called no-fault just causes. And so back in 2019, we got the Tenant Protection Act of 2019, AB 1482, that apart from certain exemptions, tenants, you had to have a just cause to evict a tenant. So what AB 3088 does is expands who's protected by this. So whereas under the original AB 1482, for example, a single owner of a home that rents it out was exempt from AB 1482, they're now included. So all tenants are afforded the protections under AB 1482 right now until January 31st. And so that means no cause evictions are not permitted. That would be just a simple 30 or 60-day notice. I no longer want to rent to you. I don't have to give you a reason. Those are not permitted until February. No fault evictions are permitted. And no fault evictions would be something like the owner move in. You want to take the property off the rental market. Red tag, things like that. There are also substantial renovations, although those are limited to severe habitability issues. Those are permitted, but as we'll see later, it's really important to put that in the notice. Otherwise, those notices are invalid. And of course, at-fault evictions are permitted, and that would be nuisance, criminal acts, allegations of violating the lease somehow. But again, that notice must specify the cause. And we did leave the link up there to see the full list of just cause evictions for your, hopefully make it easier for you all to find. So another thing we're seeing a lot is that there's still a request from landlords for financial documentation. And part of this, I'm sure, is left over. That was part of the requirement before we had AB 3088. That was the local requirement here in Marin County. But it is no longer a requirement. And in fact, continued request of documentation could potentially be considered tenant harassment. And so it's important, whether you're working for the tenants or working for the landlords, to inform people of their rights inform them not only of their rights not to be harassed, but the liability of, what harassment could mean in this current climate. There is, though, if you make approximately 180,000 in Marin County, which is none of our clients, then the landlord can request and that money has to be the actual income at time the rent is due. The landlord can request financial documentation.
And by none of our clients, Lucy meant Legal Aid of Marin's clients,
All right.
not all of you.
Thank you. Thank you, Lori. And then finally, AB 3088 did build in what we're calling pretextual, trying to avoid pretextual eviction. So many of our clients who haven't been paid or haven't been paying rent, sometimes a landlord might find another way to evict them. And some of those reasons may be absolutely valid, some maybe not. But according to AB 3088, if you do try and evict a tenant for a permissible reason, you can't then recover any of the back rent. And then if the tenant can show that the landlord is just evicting to retaliate because they weren't able to pay, there's actually additional penalties created by AB 3088, and it's $2,000 per retaliatory act and potential attorney fees. Our federal protection.
Could you repeat that again, number one?
The slide before, Jackie?
Yeah, if he files an eviction based on something other than non-payment, like, they're doing something criminal, they cannot collect rental damages that accrued between March 20th and January 21st.
Yeah, so if a landlord if a tenant is already behind in rent, but the landlord finds another reason to evict you, whether it's the owner wants to move in, whether they allege a criminal act is happening on the property, whatever it is, the landlord, they can go through without eviction. They just can't collect any back rent. This is to avoid landlords who are looking for reasons to evict people because they haven't paid, but they know that they can't evict them based on the non-payment. So they're looking for another reason.
But what if there is another reason? What if they?
Yeah, and there could very well be a valid reason, but if you, let's say the owner wants to move in and you notice it correctly, and the tenant is behind on rent, you can go through with the eviction, you just can't collect back rent. You can't collect that rent that was accrued during the protected or transitional period.
Okay, I'm thinking of like a tenant who's carrying on a prostitution ring in the apartment. And then I just.
Yeah, I mean, it's the same thing. That you can
hasn't
still
paid rent.
And,
So
and
then,
we can talk more about this later.
Yeah.
I'm marking it down for my FAQ and for question and answer.
Okay.
I
yeah.
have to push Lucy along.
Yeah, go ahead. Okay.
Very good question, Jackie.
But I appreciate you bringing it up. Thank you. So our federal protections, they have since expired, but so the CARES Act had provided an eviction moratorium for anyone that's in federally subsidized housing. It did expire on July 25th. However, drafting error again, possibly. While if you're in a federally subsidized housing, a normal notice to pay or quit must be 10 days. The CARES Act made that 30 days.
Right.
And it's actually in perpetuity until the federal government fixes that. So even though that the CARES Act is expired, they still, owners of subsidized properties or landlords who have Section 8 tenants must still provide a 30-day notice to pay or quit. And this isn't so much a, we're not seeing this much anymore, but it still could pop up. The CDC order, the CDC ordered that another eviction moratorium. Theirs is based on, that's just good health policy. We don't need people moving around, getting evicted, trying to find another place to live and having to defend themselves during this time. We need them to shelter in place. So the CDC's order provides a declaration, and this declaration, unlike AB 3088, can be provided at any time, and including if there's already a writ issued where the eviction's already gone through and the sheriff has posted on the door, we're going to lock you out in 5 days, and that is supposed to halt all evictions. And where this has been useful is for evictions that had started before March 16th, before the state of emergency. So if a tenant falls out of the protections of AB 3088, the CDC protections may still apply. There's certainly been some challenges in court throughout the country on, and especially in California, where, you know, our governor said the CDC or AB 3088 preempts the CDC order because it's stronger. However, we're seeing in different jurisdictions, judges are saying different things and often accepting this declaration pursuant to the CDC order to stave off evictions. But it only lasts till December 31st. So it's definitely a tool if you're trying to buy a little bit more time for a tenant to find another place to live. Now the Marin County protections. Most of us here practicing landlord-tenant law in Marin are pretty familiar with this one. We had multiple extensions, and it did expire on September 30th. The only relevance of it now is that landlords cannot charge any late fees through September 30th, and this would, you know, come in with the whether it's in the notice or just in a billing, you know, spreadsheet. If they're charging any late fees between March and September 30th, there's going to be a problem, and possibly a problem with with a failed unlawful detainer as well. Really quickly on rent increases. They are still allowed. And we are seeing a lot of them. We do still have mandatory mediation in certain cities as well as the county. And there's a link here where you can see a table of where mandatory mediation is required. Keep in mind though that mandatory mediation in Marin County has no teeth. But it can help, you know, if you have a amenable landlord and a tenant, you know, the mediators in our DA's office really try to get an agreement when there is a rent increase. And a lot of times that agreement can include fixing certain habitability issues. We do have 2019 as part of the AB 1482 from 2019. There are tenant protections for increases in rent, but that doesn't, unlike the just cause protections, the rent cap doesn't necessarily, wasn't also expanded. And it also leaves out those that are in subsidized housing. And so in a lot of our affordable housing in Marin, we are seeing pretty large increases. But for those tenants that do qualify for these tenant protections as far as rent, it's 5%. It can't be increased any more than 5% plus what the CPI is. And this year it was, I think I made a mistake. It's actually 1.1%. So anything over 6.1%, if the tenant isn't exempt from these protections, is an unlawful rent increase. And then finally, we have anti-price gouging law, which is criminal. So you really want to be careful of this one. Anything over 10% during a state of emergency can be considered price gouging, and that goes to our Attorney General. And so rent can't be increased more than 10% of what it was in March 2020 when the state of emergency was enacted. However, again, certain affordable housing, so low-income housing, tax credit housing, it's still arguable whether they can raise rent over 10%. So one thing that you want to do when you're checking to see if a rent increase is lawful is to look at the LIHTC laws, and certainly we're available to go through those with you because it is kind of complicated. That's more in the tax area. It's TCAC, California's tax committee that regulates LIHTC, low-income housing tax credits, and not within housing law. So it's a little weird, but.
And I just want to pipe in, the reason obviously that Lucy is talking about Marin County ordinances is because that's, Legal Aid of Marin is helping people in eviction proceedings in Marin County, but most of the counties throughout the state of California who have significant renter tenant populations pass some sort of ordinance. So if you're not in Marin, you should definitely be checking your local ordinances to see how they play in with the eviction.
Yeah, all the Bay Area counties did pass something. And in fact, San Francisco, I'm in deep admiration, they have recently passed a moratorium on those no cause, just cause evictions. So now in San Francisco, it's only Ellis Act evictions and cases where health and safety are at risk. So if an owner wants to move in San Francisco, that is no longer a permissible eviction for now. And so notice requirements. So an unlawful detainer has to be based on a valid notice. And this is where we see most of the cases get thrown out of court. And so again, we've already discussed the notice requirements for the protected period as well as the transition period. And that if it is a no fault just cause or a for fault, such as nuisance or lease violation, that must be stated in the notice. We have already had a few no cause notices thrown out of court, or the whole unlawful detainer thrown out because the landlord didn't realize that they were now subject to AB 3088 and those expanded protections, and that they have to state that cause in the notice itself. And now I am going to turn it over to my esteemed colleague, Josh, who is going to go through the actual litigation of unlawful detainers.
Thanks, Lucy. And actually, before I start launching into those details, I wanted to recommend a book by sociologist Matthew Desmond called Evicted. It really does an excellent job of talking about, well, the importance of establishing stable housing, and particularly with stable housing transitions in which the legal process plays a small but significant role. And with respect to the unlawful detainer process, and for those folks that don't practice in landlord-tenant law regularly, it's evictions in short. I can think of three primary characteristics of an unlawful detainer. The first, it's a very fast-moving case. It can be as little as a month between the filing and service of the complaint and getting to trial. The second real characteristic is that the focus is really narrow. It's possession of the unit, the house, or whatever is at issue. So for those that, again, litigate in other areas, no opportunity to cross-complain. You can have some affirmative defenses, but mostly it's a very narrow focus, and it's who gets to live there. And then finally, precision is a third characteristic, and it really runs more toward the landlord and the landlord's attorney. They, as Lucy alluded to with the notice issues, they got to really dot their I's and cross their T's. There is some precision required on our end, but more so, we, relative to, again, what I consider regular litigation, get some second and third bites at notice issues that don't always come up beyond the demurrer stage in regular civil litigation. So just harkening back a little bit to the last slide, the timeline is a compressed timeline. So it can be something where clients come in, and if they have been sitting on it for a few days, it can be an extremely compressed timeline. But it also bears a lot of attention in scrutinizing the complaint for the reasons that Lucy provided. One thing that I'd like to stress is that there's a really great resource out there. One I direct clients to, and I use myself very regularly, and it's courts.ca.gov. If you go to the self-help tab, they'll have another tab called the eviction process, and under the eviction process, it'll discuss that process in 7 steps, going from pre-complaint all the way through post-judgment. And you can do it from a tenant's perspective and a landlord's perspective. Lots of helpful links. And for the folks that are Spanish speakers, you can hit a button and it gets translated into Spanish. And it's something that, again, I go back to regularly. And if I'm not mistaken, they'll even throw in a few helpful videos. With respect to these bullet points, though, I'd like to focus on a few. And the first one I'd like to focus on is the fourth, and that is the request for trial setting. That is what gets the case on track for trial, as stated, but there's a couple other elements. The first is it's statutory, 20 days is what the requirement is, so that kind of underscores how quickly things happen. Here in Marin, though, our mandatory settlement conferences are typically tied into that notice of trial date. So when a litigant gets the notice of trial date, they'll also get the notice of mandatory settlement conference. And while we lobbied for more time between a mandatory settlement conference and the trial date for our about to resume Zoom conferences, it's still not a tremendous amount of time, although we're looking at, say, the Thursday before a trial beginning the next Monday, Tuesday, or Wednesday. The other
Gosh, what was your reference again?
with respect to request for trial setting,
Yeah, the first reference that you gave.
it's more of a, again, I don't have the statute that gives the 20-day part, but it's again tied in more locally with our mandatory settlement conference calendar. So the court now will be putting in the mandatory settlement conference info with the notice of trial. And then the thing for, and this is something to advise tenants, those that want to take this to the mat, this is your opportunity to request a jury trial when you get that notice of trial setting. Again, courts right now, as they are across the state, are loath to have jury trials. We're not requesting or advising tenants request one across the board, but this is the opportunity for the tenant to do so if they want to make a timely request for jury trial. The other element I want to touch on here is the second of the bullet points, and that is there is a drop box at Marin Superior Court. Whether you're doing it or whether you're working with someone who's doing it for themselves, and because these cases are so fast moving, and I speak from personal experience now, don't use the drop box. it more likely than not will lead to some sort of misunderstanding at the very least. And the amount of time that it'll probably take to undo that drop box will more than outweigh waiting for the clerk's office or the clerk's window to open and get it filed on a person-to-person basis. So there have been an overlay of 3088 protections since the statute was enacted in early September. One of those is a supplemental cover sheet. And the link will kind of give you your own look at the cover sheet if you're interested. To me, the purpose of the cover sheet is for the court to be able to ID cases, and this is something that Jackie and Lucy touched on earlier, where failure to pay is at issue. And my understanding then is when those cases are flagged, then those are ones that may get extra scrutiny. I had one actually though recently that came through. The supplemental cover sheet said, yes, this is all about failure to pay, made no problem going through the clerk's window. And I've use that as a grounds for a demur for a failure to state a cause of action, because in the instance I was referring to, our client had served and the landlord had acknowledged it had received a 15-day notice. So we'll see if that's something that the court agrees with. But to me, that cover sheet then is supposed to be something that the court can use to track these cases where failure to pay is at issue. I'm not sure from my practice whether it's getting quite the scrutiny I would hope it would be getting. The second element, though, is what I was kind of referring to a couple slides ago, and that is tenants get a second or third bite, even if they don't submit that timely 15-day or rather declaration of financial hardship or declaration of financial distress when they receive a 15-day notice. You know, the first bite is to get it back in the 15 days. Second bite, as Lucy talked about, you can go in ex parte. Third bite is unlawful detainer gets filed by your landlord. You can go in, you've got a safe harbor 5-day window, or rather the client has a 5-day window, gets the declaration in and can satisfy the 473 excusable neglect essential standard. And then the case then gets it goes away. So certainly it's a process that is much more tenant friendly. Unfortunately, the question, or the answer to the question, answer to demur, has to be made on a real quick basis. As one might expect, the demur in an unlawful detainer action is not heard at the usual statutory timeline as a typical demur of 16 court days plus service. I filed a demur on October 1st, and the court set that demur hearing for the 13th. So there are some provisions for hearing things on shortened basis or shortened time. Any landlord that I've experienced really wants to have things heard on that shortened time, is not going to fight the notice aspect. And so if you are demurring, it's not going to be something that creates quite that temporal runway as you might expect. Demurs really are quite viable in this litigation for the reason I talked about earlier. Even though it's ones where the pleadings can be checking the correct boxes, the demur I just referred to, the plaintiff failed to check two crucial boxes, and one that related to its right of possession to the premises. And so in effect, landlord's attorney failed to check a box. My client files a demur, kind of case gets sidetracked now for up to a month. And so these sorts of things are highly procedural, as it says, and the courts do look at it in great detail, and they don't shrug. And so it can be, when it's paired with maybe a client that's looking for additional time, a valuable alternative to file an answer. turning quickly to answers. Again, I would advise for forms, go to ca.courts.gov. They've got a whole set of under self-help of forms, and then you'll find the latest. Unlawful detainer forms, as you're hearing, are changing, and they're changing kind of quickly. So the latest and greatest of the UD answer, UD 105, is available there and has a whole host of available sorts of defenses, affirmatively and not, that weren't in the form that was in existence just mere months ago. Also, really quick in passing, in addition to a demur or an answer, as noted here, motion to strike can also, a motion to strike's not there. Motion to strike can be appropriate when there's no verification to the complaint. The complaint must also be signed and verified. Something as simple as missing a signature line on that form could mean you can file a motion to strike. Motion to quash, as in regular civil litigation, mostly relates to service. And yes, service can be a problem here and can be challenged not only at this stage, but on latter stages. So if you don't have the time, you can keep your powder dry and challenge it even at trial. So I got slightly ahead of myself. So this is the list of some of the commonly used forms in unlawful detainer litigation. The top area, particularly with one for people that are filing answers from our clientele, if you qualify for legal aid or Marin services, you almost invariably qualify for a fee waiver. Which means that that litigant does not have to pay to file a responsive pleading, any sort of discovery motions, and it essentially gets that litigant all the way up to trial, at which time there'd have to be a renewed one. But it's very valuable, particularly for folks that just don't have the money to participate in this sort of litigation. But in short, if you receive some form of public assistance, secondarily, if your income is within 125% of the federal poverty level, and then finally, there's a third tier of folks that consider themselves financial hardships, you may qualify for a fee waiver. With respect to public assistance, you don't have to provide any additional information. You have to provide some income level for the second level, and then for that hardship, there's a lot more that's required. But again, these are forms that folks filing answers should be conversant with, because in my experience, the answer very often goes hand in hand with the fee waiver, and the FW003 is simply the proposed order, which must be submitted with it, and it's a very simple form to fill out. It's really not highlighted on this particular slide. There's a reference to form interrogatories, but again, to me, it bears mentioning that if one gets an answer and it's an answer where there's a case where you think you might find yourself even close to trial, I would advise serving discovery with the answer. There's, again, different than civil litigation where it's written discovery, it's about 30 days to respond. It's 5 days to respond here in unlawful detainer land. But those 5 days, because we're not have tons of resources, you got to add 5 if you're mailing it, 2 if you're overnighting it, and hand service, unless someone's around the block here, is really not viable for us. So you can recognize with something that could be in trial, so very fast, and with a discovery cutoff 5 days before trial, you might as well get your discovery out with your answer. I know I might be getting too far in the weeds here, but if you have a case that's really worth fighting, it's something that I really strongly recommend, because I can't say much more from my experience than, time flies in this litigation. Just a couple quick points on this just basic settlement slide. And I know that it's probably almost, I don't know what I would call it, lawyer-splaining, but be proactive, and it's kind of common sense. In our experience, our clients leverage declines as it gets closer to the mandatory settlement conference. And so I know it kind of dovetails with be proactive, but if you find yourself in the position of getting the opportunity of trying to, or getting to settle a case, if you can get at it and start the conversation soon, or as soon as possible, to me, that maximizes a positive outcome for the client. Whew. Well, so I think I mentioned this just a little bit a while ago, but we are on the cusp of a resumption of formal mandatory settlement conferences at Marin Superior Court in a pairing with Legal Aid of Marin and the courts. And that date is December 3rd, which, as I know, will be on me before no time. And so it's going to involve up to 8 Zoom clients at a time. And unlike what we had when we were doing in-person pairing with the court on mandatory settlement conferences, these are going to be held on a weekly basis. And so with the number of potential unrepresented litigants and having them every week rather than every other week, you know, the need for continued pro bono support from you and others is absolutely necessary and appreciated here. These are kind of uncharted waters for us in the court. Right now, we're really only seeing what we call behavioral unlawful detainers, but we really don't know what's coming around the corner, and really appreciate folks that have made themselves available and those that will. Turning down to the settlement sections, that also to me is going to be an area going forward that we're going to have to kind of figure stuff out on the fly, because when we were in person, there would be a settlement and then things would get signed in the hallway and delivered to the judge in chambers. And then at the end of the settlement conference, the parties could walk away with a settlement in writing that they could reasonably rely upon. You know, here, the court does not accept, at least for filing, wet ink signatures. Maybe they'll get a little bit looser in that way when it comes to settlement agreements, but we foresee and we don't know that there might be some stuff that goes on when an individual or an attorney settling it, where the court's just going to want to put it on the record and then put it in writing later. That's kind of to be determined. Pay attention and definitely use your radar with plaintiff's counsel. Certain attorneys will definitely lard their settlement conference or settlement agreement with some unfavorable terms. Most of the landlord attorneys around here are straight up, but stuff like attorney's fees that come, as noted here, with a pay and stay do happen. And so you know, look it over, and also make sure during the process, because certainly we explain it in the beginning, but it bears in the end discussion too. There's plenty at stake here, and a tenant who does not prevail at trial really can face a judgment that follows them both on their credit as well as their ability to secure future housing. And I don't use that as a boogeyman during settlement, but I certainly use that as a, hey, this is eyes open, this is what you get, this is what you trade off, and this is what you're risking when you get to trial if you get there.
All right, I'm going to jump in. We have about 8 minutes left, and I think I'm going to just respond to some of the questions in the chat room because they are easy responses. One asked for, can we get the PowerPoint? Yes, for people who weren't on at the beginning, you can get the PowerPoint. We've posted it on our website, marinprobononetwork.org. That will be our last slide that we show you just to keep you on the whole time. And I can email it to everybody as well. So yes, the recording and the PowerPoint will be posted. Someone asked if MSCs are all going to be by Zoom for now. Yes, all MSCs are by Zoom for now, none in person. And then the last question was, is there a benefit for a tenant to convert rent to consumer debt as opposed to tenant debt? And I'm just going to jump in and respond quickly. Lucy and Josh can answer. The reason a tenant would prefer to have their debt that they cannot pay, be consumer debt and a small claims judgment against them. I mean, if they're choosing their poison, of course they'd choose to have none of the above. But if they have to choose between rent debt and consumer debt, our clients are going to choose consumer debt because one, they don't want rent debt being used as a basis for eviction, but two, any rent debt evictions go on the record, the court record, as an unlawful detainer eviction. So consumer debt, it's just going to be a small claims judgment. And the reason this is important is because the vacancy rates generally are so low for people to find other housing if they're looking for other housing, and a landlord sees an unlawful detainer judgment against the tenant or rent due judgment against the tenant, it makes them, they basically might as well have bubonic plague, because landlords do not want to rent to a person with judgment. Lucy and Josh, do you have any more to add to that?
No, that sums it up. One causes an unlawful detainer, which can really make you homeless for quite some time. It stays on your record for 7 years. And the other becomes something that's essentially credit card debt. Optimally, we hope that we can keep as many clients as possible out of court at all and come to some sort of settlement agreement where when they start working again, they can start paying this debt off little by little to the landlord. And that's what many of the tenants express, that it's not that they can't pay rent, they feel awful about it, and really look forward to getting into a position where they can start paying their landlord back.
I also have a question in the chat room from one of our longtime volunteers who would go out into the hallways in the court and try to settle cases, Rebecca McGuire. And so she's asking, how the heck are you going to do that on a Zoom conference? Very good question. We're nervous about it, but we are going to set up breakout rooms for the confidential conversations, and then you leave the breakout room and go talk to the other side. We're going to pilot it December 3rd and see how it goes, and then I'm probably going to start calling all of you to see if you're willing to help. Michelle Kwong asked, will we be assigned individual clients, or will we be participating in a clinic style format? We assign individual clients, and then you'll have one of the mentor attorneys, myself, Josh, Lucy, one of our housing attorneys, supervising and helping. Bob Samus asked, notice that must be given by landlord in transition period per month, anytime during the month or within some time period after the rental due date. Lucy or Josh, Bob is asking about the timing that the notice that the landlord must give during that transition period, September to December. Is it any time within the month, or is there some specific time after the rent due date?
To me, it was now, rather than a 3-day notice, it's now a 15-day notice. And so the landlord could serve a 3-day notice after to quit or pay after the failure to pay or the time to pay expired. So I think it would be the same thing here, but rather than a 3, a 15, and would be applied.
All right, so we have about 3 more minutes. Oh, sorry, Lucy?
Well, I just wanted to add really quick, again, that's something left out of drafting, and that might have to be answered by the court. So let's say a tenant doesn't pay November and December, and a landlord gets a 15-day notice out in December, but not in November. Is that going to mean that the landlord can't collect November? We don't know yet. This might be part of the cleanup in January, or it might be something that our court is going to have to decide. Good
point. There are waiver arguments out there first.
And the last question is, can recent grads who are awaiting California bar results volunteer? Well, as you probably know, you can't give legal advice, so you wouldn't be able to do the settlement conferences or probably assist with the answers. But there are other things that can be done, interviewing clients over the phone, getting their information, the proofs of service, things like that. So we're happy to put every volunteer to work in some way. I don't know if we have time for a hypo, Lucy? 2 minutes?
I don't know. That takes me back to law school. It gives me shivers. So I think that certainly read them over if you have a chance. We're all you have, or you will have, all of our email addresses. Please bring on the questions.
Or unless in hypo 1 and 2, are there some sort of bullet points you want to make, Lucy or Josh? any points that jump out at you from the hypos, and then people can read them after.
It's been I wrote them, but it's been a while. I think this one just, yeah, talks about
This is where the landlord failed to give the notice by the deadline of September 30th. I think that's what it's getting at.
yeah, so again, that's the question, whether the landlord is precluded now for going after rentering the covered period if they didn't get that first 15-day notice by September 30th. And Josh might have mentioned this though too, but I think I was also touching on, you know, we do occasionally have what's called sewer service in Marin, where landlords say they served something, but they really didn't. And you know, the POS will say, you know, under penalty of perjury, I served this, but the tenant didn't get anything. So certainly watch out for that, as well as the master tenant and subtenant relationship, where, you know, a master tenant would get a notice, but the subtenant might have no idea. They might have continued to pay their rent to the master tenant. The master tenant kept the money and didn't pay the landlord. They might not even know that they are threatened with eviction.
Thank you, Lucy. We have demand from the chat room to give a quick response to hypo number 2, which is where the tenant paid partial rent between March and August and then full rent in September and October, but she received a 60-day termination in October with no cause. But the owner texted her saying he wants to sell the property, which is a condo in a large complex. So yeah, it's a law school exam.
Yeah.
The point here is the issue.
No, in fact, you know, I wrote this hypo probably a month ago, but I just got an unlawful detainer tossed, you know, by demurring on these very same facts, that the landlord had previously, you know, is a single owner and were not subject to 1482. The tenants hadn't been able to pay for the past couple of months. The owner says they want to move back in, but they just had a regular notice and didn't, even though the tenant and the owner have communicated about the owner wanting to move back in, that has to be in the notice, and that's what the judge ruled and put in the tentative ruling. And if for some reason then the owner comes back and does serve a valid notice, they wouldn't be able to collect any of that back rent.
Thank you, Lucy, for doing that. So
Sure.
zippy. So we are 1 minute over time, but I would like to ask Maria to move to the last slide, which has our secret password on our website in order to access the recording or the PowerPoint. And also my email when you eagerly want to contact me to assist with pro bono work in eviction proceedings. So I thank you all for attending. We will be in touch. Thank you to Kecker, Van Nest, and Peters for helping us with the CLE compliance. We'll be sending those certificates along with the survey, and I will check the chat room for any additional questions and follow up with you. Thank you all.
Thanks.
All right.
Thank you.
Thank you.
All right.
Can we
Bye-bye.
print, the PowerPoint presentation, this information, can we get that printed?
You can print it. Yep. You just click on, when you go to the website, you click on download.
This is the website.
To the website, yeah, with our magic secret password in there on the slide.
Well, that's what I wanted to have print, was the,
Oh, you want that? You know, I'll email it to you. I'll email this to everybody.
yeah, please, okay.
And then, yes, when you go into the PowerPoint, you can just click, not the PowerPoint, I'm sorry, into our website, you can just click on download and you'll get the
Yeah,
whole.
that would be great, thank you.
Okay. Thank you all for your attention. Thank you, Lucy and Josh. Someone asked if you are legal aid of Marin attorneys or have your own private firms. Josh and Lucy are both legal aid of Marin, fabulous, awesome lawyers. So,
Terrific, yeah.
thank you all.
Thank you.
Thank you.
Have a good afternoon. Bye-bye.
Bye-bye.